Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
On May 25, 2018, a 14-year-old girl confided to her aunt that her father had been sexually abusing her since she was 10 years old. He would hurt her whenever she refused his advances. Her aunt then took her to the barangay hall and the police station to file a complaint. In her sinumpaang salaysay or sworn statement, the victim narrated to the police the harrowing specific details of abuse done to her by her father, with the most recent incident happening just the night before. She also filled out a sexual abuse protocol form which stated a brief history of the incidents. She later underwent medical examination at the Police District Crime Laboratory. The medical legal report indicated that she had deep-healed hymenal lacerations. During the trial, the prosecution was unable to present the victim as a witness because her mother had sent her away to prevent her from testifying against her father. In place of the victim's direct testimony, the prosecution offered her sworn statement and the sexual abuse protocol she accomplished when she first reported her father's abuse to the police. The prosecution also presented the medical legal report and testimonies from the victim's relatives. The Regional Trial Court, applying the doctrine of unavailable child under Section 28 of the Rule on Examination of a Child Witness, found the accused guilty of rape. The accused appealed the ruling of the RTC to the Court of Appeals. Claiming it as hearsay, he argued that the victim's statements should not have been allowed as evidence because she did not testify in court. When the CA affirmed his conviction, he brought his case to the Supreme Court. Ultimately, the High Court dismissed his appeal. How do you examine a child witness in court? Can courts allow the statement of a witness to be presented as evidence in place of direct testimony? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 11th of April 2025, and today we talk about the examination of a child witness within the context of the Supreme Court decision in the case of People versus XXX 258054, GR number 258054, decided on October 25, 2023, penned by Supreme Court Associate Justice Mario V. Lopez. And joining us once again to talk about this case is Attorney Paolo J. Santiago, member of the Philippine Judicial Academy's Department of Humanitarian Law and Human Rights. Hi, Attorney RP. Welcome back to the Supreme Court Podcast.
Hi, Attorney Mike. Hi, everyone. It's nice to be back.
Right. And Attorney RP, let's begin with this topic today on child abuse. How significant is the testimony of a child in a child abuse case? Do you really need the child to testify to prove your case in court?
Okay. As a general rule, the testimony of a child in a child abuse case is very weighty, because you're able to look at the competence and credibility of the child. You're able to observe the conduct of what he or she is saying, and you're able to test the credibility of the child. Again, that is in usual and normal circumstances. But because of at present times, we now also look into the child as someone who has to be protected. A child is a minor, and under Philippine law, anyone below 18 years old or anyone who might be above 18 but does not have the mental capability of an adult is considered as a child. And under the Constitution, they should be given special protection. So part of that special protection is not allowing them to be re-victimized of an abusive experience and a harrowing experience. So right now, we have rules, particularly like the rule on the examination of a child witness, which allows a certain accommodation in order to protect the well-being, safeguard the well-being of the child, protect and safeguard the interests of the child, but at the same time, also protecting the interest of any person accused of
Mm-hmm.
such abusive crime. No? So
Mm-hmm.
it's a balance of the interests of these two individuals in a case.
Hmm. Before we go to the case, Attorney RP, let's talk about the safeguards that are in place to ensure that the rights of the child are protected. Because as you mentioned, testifying over and over again about what was done to a child is a very traumatic experience, and various studies have shown that. But at the same time, you need to also discuss that in court because that's what you're trying to prove. So, what are the safeguards in place so that the testimony of the child can be least harmful, at least? To the child.
Okay. In the rules on the examination of a child witness, it provides a child sensitive approach to handling these types of cases and testimonies. So
Mhm,
that includes having a child friendly courtroom procedure.
mhm,
So, for example, the family court judge can ensure that if he or she wants to have the testimony of a child in another room where it is
mhm,
less intimidating, that can be done. The family court judge could also exclude the audience in the courtroom because a court proceeding is a public trial.
right.
But in order to safeguard again the feelings of the child, so that the child will be less intimidated, then that can be done by the family court judge. Um, the court can use facilitators and support persons.
Mhm,
So the child need not be alone in answering questions. There could also be a facility where the child is in another room and there's a
mhm,
closed circuit television or camera so that the accused is still able to see the child, but the child
mhm,
is shielded from the accused. Because
mhm,
again, in child abuse cases, there is this emotional and psychological trauma, even
mhm,
with the sight of the perpetrator present in the same space. Leading questions are allowed because they are
mhm,
children. In our rules of court, usually leading questions are not allowed in direct testimonies, but they are
mhm.
allowed for children. And there is also an exception for hearsay with regard to children. And this is one thing that has been covered by this particular case as well.
Right. Precisely, and you're referring to the doctrine of the unavailable child. But before we get to that, Attorney RP, in this particular case, what were the allegations against the father of the child? Can you walk us through that harrowing experience and how this could have been harmful had the child been testifying again regarding her experience?
Okay, based on the facts of the case, the perpetrator is the father of a minor child. The child
Mm-hmm.
is 14 years old. And according to according to the statement that was given by the child, she suffered this sexual abuse ever since she was 10 years old.
Mm-hmm.
So there was this incident when she was already 14 years old, when it was only the father and her in their dwelling, that at knife point she was asked to undress, and she was sexually abused. She was raped by her own father. And because of that incident, well, she cried. She was able to tell family members. But of course, the defense of the father was that he was not there. He was
Mm-hmm.
in another place where he was staying with the twin, actually, of the child here.
Mm-hmm.
And I think what makes the story further interesting, in a sense, is the mother of the child herself didn't want to believe the testimony of the child, to the
Right.
point that she sent the child away after being able to give those testimonies before the police authorities, after her the child getting a medical legal examination,
Mm-hmm.
documenting the lacerations to her vagina. The mother refused to believe the story and sent her to another place. It was actually not disclosed in the case itself because
Right.
they
Mm-hmm.
even, well, it was redacted But it looks like she was sent to a place far from where it happened
To prevent her from testifying.
to prevent her from testifying.
It's interesting that that was what happened in this case, because I was sort of thinking, what could have the court done? Could it have compelled the mother to bring the child to court so that the child could testify? But we did know that the court did apply this doctrine of the unavailable child and relied instead on the affidavit or the sworn statement that the child executed when she was still available. But the question here, Attorney RP, how do you balance that? Because you do have this sworn statement, it was taken under oath, but you also have the right of the accused to confront the witness, right? So in this case, is it at all possible to secure a conviction even if the accused cannot confront the witness?
Okay, for your earlier question about the mother is an OFW, an overseas Filipino worker. It was not discussed in the case, but it seems when I was reading the case that she was no longer available as well, and they had no access to the child. So no one could actually compel the child to testify in court. And that's what made this case also interesting, because we're looking now at the doctrine of the unavailable child. And can we use documentation of her statement to actually convict the respondent, who is her own father in this case? And the question, again, it was raised of whether would it be unfair for the accused, since there was no opportunity to confront. Um, we have to balance it with the constitutional right of the accused to confront his or her witnesses. But in this particular rule, the rule on the examination of child witnesses, we're actually balancing two rights here. Well, balancing the interest, actually, not the rights itself, but the interest for the child is to protect the child against being re-traumatized, being re-victimized. And again, in this case, it's not the child not wanting to testify before the court, but it's really the child was unavailable to testify because she was sent somewhere else. The interest of the accused is to be able to properly defend himself, and this is through the confrontation of the witnesses. So the Supreme Court pointed out here, there is no absolute denial of confrontation. In fact, it does not completely deprive the accused the right to challenge the testimonies, because there were still corroborative evidence that were presented. And in this corroborative evidence, the accused can actually question these alternative or these corroborative evidence that actually just corroborates the statement of the child. Because again, if the corroborative statements do not stand the test of being exacted in a cross-examination, then it will not be able to corroborate the witness of the testimony of the unavailable child. No? So the prosecution's evidence will falter. And the Supreme Court also points out that the burden of proof is still actually with the prosecution to prove that the crime, in this case, qualified rape, actually happened beyond reasonable doubt. So again, the balancing of interests is allowed under our rules and by Philippine jurisprudence, but there is no deprivation, of the rights of the accused to confront the witnesses that are testifying against him or her.
So what about the rule on hearsay, Attorney RP? Because you understand that if you cannot testify in court, then your statements is considered, or your statements are considered hearsay. But this is an exception to that rule, right? The doctrine of the unavailable child is an exception to the hearsay rule. So how so?
Yes, in this case, the Supreme Court laid down certain requirements. And again, one of the requirements is that it will not stand alone without corroborative evidence and testimony. So indeed, one might say it's hearsay because it has not been testified on in court.
Right.
But the reality is that the statements themselves are not hearsay because they were actually given by the victim herself to the police authorities, for example. The statements that were documented were actually heard by people surrounding her at that time. And this is interesting because the Supreme Court is not merely relying on the statement of the unavailable child witness. The Supreme Court allows these statements, will look at the evidentiary nature, how dependable these statements are, depending as well on the corroborative witnesses and how they all gel together. So it's not a standalone statement. And that is where, again, to point out, it's not as if the child is testifying on hearsay evidence. The unavailable child is testifying on her own experience that happened. It's just that she's not available to testify in court. And what is being said as hearsay here is because the other witnesses got their personal knowledge from those statements of the unavailable child. But in this particular case that you mentioned, the Supreme Court also pointed out that it did not only use the rule allowing the unavailable child witness, it also allowed principles such as it was stated this res geste.
Right.
Res geste is a term, it's a Latin term, which is an exception to the hearsay rule
Hearsay.
of our rules of court. No, res geste is when there is a startling event that happened, and in that instance, you hear someone say something, and based on that statement, no, the Supreme Court says it's a res geste statement simply because the person who you are quoting had no time to think of or concocting any other story regarding that incident. No? So going to this case, a cousin actually testified that minutes after the harrowing event, uh, the victim here, the child, was actually telling her of the story of how she was raped by
Right.
her own father. And the Supreme Court looked at the timing, looked at when it happened, and the Supreme Court concluded that this is a res geste statement, quoting the victim because at that moment there was a startling incident, and this was the rape that actually happened, and there was no time for the victim to concoct a story. So it was spontaneously given to the cousin. No? So when the cousin testified that this is what her cousin said, the rape victim actually said, the Supreme Court also allowed it, no, as an exception to the hearsay rule. So that gave further credence to the testimony of the unavailable child.
Right. So rest just stay as to the statements of a child immediately after the starting occurrence. But with respect to the affidavit, the sworn statement that was executed obviously days after the incident, that's where we apply the doctrine on the doctrine of the unavailable child under the rules.
Yes,
Right.
because that statement was given by the victim herself. And because she was brought to another place, there was no opportunity anymore for her to be able to testify in court. But since these were given based on the interviews of the police authorities, again, this was allowed by the Supreme Court as evidence in lieu of her testimony.
So you have her testimony, you have corroborative witnesses supporting her statement, as opposed to the alibi of the father saying he was somewhere else. So in the end, how did the court appreciate all of these evidence?
Yes, the Supreme Court has always pointed out that alibi is actually the weakest evidence, especially so if your alibi allows you to be in two places within that period of time. So in this particular case, the Supreme Court also concluded it's not impossible for the father actually to be in those two places within a certain time frame
Mm-hmm.
because they're quite near each other.
All right, Attorney RP. Finally, let me just ask you to stress the importance of these rules, that we have these rules specifically designed to aid in the examination of a child witness. I mean, how important is this? And would you consider this a milestone in terms of the development of our legal system, that we have specific rules to cater to certain minorities or certain special cases before the court?
This is actually very important, Attorney Mike. When we were in law school, we've always had this fascination that the law should be applied equally to everyone.
Mm-hmm.
In fact, in our Constitution, Section 1 of Article 3, the Bill of Rights of our Constitution, points out that we enjoy the equal protection of laws.
Mm-hmm.
But we suddenly realized when we were in law school, when you talk of equal protection of laws, the reality is that we as a people, we as groups, we as sectors, we are actually not always equal.
Mm-hmm.
So the equal protection of laws have to apply to the same group or the same class.
Mm-hmm.
So in this particular case, there are those in our society who are more vulnerable than others and thus would need more special protection. Example
Mm-hmm.
are children. Why? Because children, being children, no, they are weaker in physically protecting themselves, especially very young children. No, they can't protect themselves from abuses such as this,
Mm-hmm.
from rape. No? So there must be special laws and at the same time special rules to be able to make them properly testify, to be
Mm-hmm.
able to tell, allow them to tell their harrowing stories in a way that will not further traumatize them or
Mm-hmm.
re-victimize them. So first, these rules or laws are important to protect children from trauma and re-victimization.
Mm-hmm.
Second, we mentioned in this particular episode that it's not only about the children or about the child in this case, but what about the rights of the accused?
Right.
So having these types of rules are able to balance these interests to ensure that there are accurate and reliable testimonies and still
Mm-hmm.
the right of the accused is protected. Um, Third, with having these kinds of special rules, it encourages actually the victims, especially children, to come forward and to tell their stories.
Mm-hmm.
Because many of them, if adults like us are, many adults are actually are afraid of courtrooms. What more children who have more often than not seen the inside of a courtroom as well, and judges in robes. So that vision can be intimidating. No? So how can we encourage them to come forward and tell their story? No? So
Mm-hmm.
I just wanted to point out these three things that are addressed by having these special rules for marginalized and vulnerable sectors of our society. And in this particular case, children.
Right. Thank you for sharing those 3 points, Attorney RP. Very enlightening for us. And if you wish to read the full text of the decision, you can go to the Supreme Court website and e-library. Just search for GR number 258054, People versus XXX 258054. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
From the Supreme Court of the Philippines, here's the latest. Supreme Court Associate Justice Maria Filomena Singh has just been chosen as the President-elect of the International Association of Women Judges for 2025 to 2027. She was unanimously elected on April 8 during the 17th IAWJ Biennial Conference in Cape Town, South Africa. Justice Singh has been serving the judiciary for 23 years. The SC has ordered two lawyers to explain why they should not be subjected to disciplinary actions. In a Facebook Live on March 11, Attorney Raul Lambino falsely claimed that the Supreme Court had issued a temporary restraining order against the arrest of former President Rodrigo Roa Duterte. Meanwhile, a complaint was filed against Pasig congressional candidate, Attorney Christian Sia, by 2 lawyers for his alleged sexist remarks against single mothers in a campaign sortie. The Gabriela National Alliance of Filipino Women, in a letter, asked the court to investigate the same incident and impose disciplinary action. The court has also required the Senate of the Philippines and the House of Representatives to comment within 10 days on the consolidated petitions of Isambayan Coalition, Kapatiran Party, and Wilfredo M. Trinidad, which ask the Supreme Court to compel Congress to enact an anti-political dynasty law. The Supreme Court has affirmed the life imprisonment sentence of a man who trafficked 3 minors to work as domestic helpers in distant towns without pay. In a decision written by Associate Justice Mario V. Lopez, the SC Second Division affirmed the conviction of Jo Marie Ubanon for qualified human trafficking under Republic Act No. 9208 or the Anti-Trafficking in Persons Act of 2003. He was also ordered to pay a fine of 2 million pesos and 600,000 pesos per victim as damages. Chief Justice Alexander G. Hesmundo on Thursday led the blessing and inauguration of the new office of the 6th Municipal Circuit Trial Court of Pozo Rubio Season, Pangasinan. The new office is located at the Pozo Rubio Community Building in Barangay Cablong, Pozo Rubio. You are now up to date with the Philippine Supreme Court. I am Tiffany Tran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rimpilio and May Sibal as researchers, Lawrence Olaño as sound editor, and Tyke Flores and Jerome Batumalaki as web editors.